Commissioner Bromer, you're on mute. Are you on mute?
No, I'm not.
Speak. Okay.
This picture just pulled up.
Okay. Mr. Executive Director.
Phil, you're muted.
Yes. I don't have any other questions at this point. I mean, the motions are pending. You've heard arguments from both sides.
May I
as to whether-
respond to any of his arguments?
Well, yeah, I mean, if that's what the commission wants to do, I was merely asked a question by Mr. Beatty. I'm responding. You have the motion. You've heard from Mr. Bry. You certainly can hear from Mr. Hicks in response to that. If there are any other additional questions, I don't have any other additional questions at this point or advice to the commission per se. Mr. Norman, it looked like you wanted to ask a question. And Ms. Cunningham, it looks like you want to.
I did not.
Oh, okay.
I do not have a question.
I have a couple questions. Okay with you, Mr. Chair? Acting Chair?
Yes, I asked for questions. Go ahead.
Sorry. Okay, thank you. So, Mr. Bry, am I correct in what I understand that at least I think that both of you are saying is that neither the complainant nor the respondent have provided discovery to the other party, correct?
Correct. Well, correct. I think Mr. Hicks has provided some pieces
200
of paper.
pages.
Okay,
Excuse me, I think
Mr.
the
Hicks.
question's directed to me.
Hang on, go ahead, Mr. Bry.
I believe Mr. Hicks has provided some documents that don't appear to be relevant to much, but he emails everybody a lot of things. I don't know whether that's all the response or whether it's responsive or what it's responsive to. Obviously, in a response to a document request, you kind of understand what documents are responded to. And he naturally has a lot of the documents, including what we filed with the Secretary of State.
Okay, so clearly there's frustration between the parties, but I need to understand, you have sent to him a set of interrogatories, which you resent, and you have sent to him a request for production of documents.
Correct.
And you have not received, you've received it, and you noticed him for a deposition.
Right. Two depositions, one by Zoom, and then a week or so later, one in person.
Okay, so 3 methods of discovery, all unresponded to. And
That's not correct. I responded.
okay, all right, you'll have your chance, Mr. Hicks. So, and do you have a separate motion to compel with us on those?
I do not.
That's what I thought. So right now, as it relates to those discovery, that's status quo, but we do not have a motion from you relating to any of those discoveries in an affirmative motion.
The filing of motion to quash stays the enforceability of the discovery. If the motion to quash is denied and he persists, obviously I'll move to compel.
Okay, understood. And so in the moment, we are here on his motion to compel and his motion to quash.
Correct.
You have affirmatively filed a motion for dismissal, which is not before us today, except for a hearing at a later date. And then you've just responded to his motions to quash. But as to the status, you've requested discovery that you have not received. He has requested discovery from you that he has not received.
Correct.
Okay. And when your arguments to the commission basically are saying, look, whether you're pro se or a lawyer, you are required to follow the rules that apply at the commission, which are the rules of civil procedure. And under the rules of civil procedure, as it relates to discovery to a party, there's a process and it doesn't involve subpoenas.
Right. He could service Rule 35 requests for documents anytime he wants to, and we respond to him. He just flatly refuses.
Okay. And the subpoenas that you received, did they identify the documents that he was wanting?
Oh yeah, they're attached to his. Well, they're attached to our memorandum of opposing motion.
In opposition, yeah. Okay.
Yeah, in opposition.
Okay. The long list that was part of that.
It's a long list.
Yes. Okay.
Yeah, I'm sure there's some stuff in there that's relevant to this case, and we'd provide that. But there's a lot that's really not, and it's just onerous.
Okay. So as it relates to documents and there's been no deposition issues from him?
Well,
your
there's
client?
been no deposition. Well, he can't depose my client because we're responded. We've noticed him and he has not appeared and refuses to.
Okay.
Although he says he's really eager to answer questions, he's found reasons not to.
Well, I understand. I don't need
I apologize.
the extra gratis comments. I'm just trying to get to what's properly before us and what we have before us to determine and how we as a commission may resolve it.
Mhm.
Okay, so have I covered it legitimately, what the issues are before us, or is there some other issue that I'm missing?
I think you've covered it. It's in his motions, they're in our responses.
Okay, thank you.
And the documents attached to them, yeah.
Okay, thank you. Thank you, Mr. Beatty.
As it relates to the notices for deposition, was there ever a protective order filed as it related to appearance at the depositions?
Am I allowed to respond on any of this stuff?
When we ask you, yes. Mr.
Okay, well, it'd be
Never
good that we were working off the truth of what happened with his deposition.
Hold
request,
on.
but-
What's Mr. Hicks? Hold on. I believe Mr. Norman was asking a question to Mr. Bray.
Right. There were no motions for
Let's finish
protective
that part
order
first, and then we'll move.
filed. There was a
on.
motion to
Mr.
quash.
Hicks to allow you to respond. Okay.
There was a motion to quash as it related to production of documents and interrogatories, but was there ever a protective order filed as it related to an appearance at deposition?
Yes, the motion to quash is motion to quash third and fourth deposition of Christopher Hicks
Right.
and second set of interrogatories requests for production of documents. So all of our discovery requests are the subject of the motion to quash.
All right, thank you. And I just never heard of a motion to quash as it relates to a deposition.
It may not be the proper way to call it, but I wasn't going to argue that one.
Okay.
She's gonna get us over to somebody else, but she's the executive. Okay. All right, at this time, if there's no more questions of Mr. Bray, we'll now hear from Mr. Hicks. So hold on for 1 second. Any more questions of Mr. Bray?
I don't have any questions, but I will interject. I see her still there. She may have to comment. I believe Ms. Tavares has run into a time conflict and is it may be obligated to leave the commission meeting at this point.
Mr. Chairman, Mr. Executive Director and Mr. Vice Chair, he is correct. I didn't realize this was going to go as long, and I have a meeting that I chair at 1:30.
Do we need to move to excuse her, Phil?
Probably wouldn't be a bad idea. Yes, I would encourage.
For good cause, I would move to excuse Ms. Tavares.
I'll second that.
All in favor signify by saying aye.
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 Okay,
Thanks,
that passes.
everyone.
Thank
Take
you.
care.
Okay, now I apologize for interjecting there, Mr. Hicks. Please respond.
Well, I took down some notes during Mr. Bray's presentation. So I just want to keep pointing out that your own rules say all discovery subpoenas shall be served by the requesting parties provided blah, blah, blah. Okay, so after all of that, okay, I just want to note that every other party that received a subpoena and by the way, I didn't ask you to do those subpoenas. I was told that's the way that it has to be done. I provided you with 14 pages of emails in my filings telling me that this is the way I have to do this by the director, okay? All that withstanding, obviously you might need to work some stuff out but Mr. Bray's in this unique position of here more than a year after this stuff happened, and almost a year since I filed this, of the argument of providing nothing. Now he makes I'm glad that I recorded him. By the way, Mr. Bray, I turned on the recording after I started realizing that you were trying to rope-a-dope me on the call. So I was accurate when I told you at the beginning, but just as a side, you can feel free to record me at any time. I have no problem with being recorded in that matter. So I pointed out your rules, okay? Mr. Bray made false representations here on the allegations in my affidavit. So my affidavit referred to media spending, print spending, Luke Householder. So I had two affidavits, I believe, and I have to check my memory. but they referred to all those things. And he referred to my affidavits only being about six invoices, which is not what they were about. So there's this constant stream of, I think, misrepresentation and ultimately this bad faith in trying to get discovery where everybody else does stuff other than Mr. Bray. Now, as it relates to depositions and his discovery request on me, go look at what his discovery request was. It asked me things like, tell us all the documents you're going to introduce in the hearing. Well, how am I going to answer? And I could give him from where I started recording our conversation, Mr. Bray. How do I do that when he's not provided any documents from him that could be used? And he told me in our conversation that if I didn't indicate a document was going to be presented and then I tried to present it, he was going to object to that and try to stop any documents. So there's this cart before the horse thing that's being played. As far as a request for deposition, notice he said 2 or whatever he said, but you said it was the 3rd and 4th notice of deposition. He's been trying to get me to do multiple depositions in multiple places. I'm glad to do a deposition, Mr. Bray. I just think it would make more sense to do a deposition in sequence of discovery. So when I did it, requested stuff in March that you're still explaining why you're not responding to anything now, to do it in proper sequence. And the deposition on the 17th, I specifically notified you. And by the way, people can go look at video. I am a volunteer at American Legion Buckeye Boys State at Miami University and was in Oxford leading a session of 2 state reps while you were trying to saying you were wanted to depose me. So this misrepresentation of me, I admit to all of you, I am a citizen, and I think that these processes of oversight should work for citizens. Yes, should I follow the rules? Should I do things as properly as possible? Yes, but I'm going to be given an instruction. You've got to rely on this process that there are people acting in good faith. Mr. Bray did not respond. First off, I think he should respond to the subpoena that I issued. I don't think anything's overly broad. He can object to things. Up to this point, he hasn't gone through what he objects to and what he accepts out of that. But let's not hide the fact that just the work and discovery that I've got right now has shown that they knew there was $290,000 worth of spending. Now he says, well, we filed a proper thing backdated into the Secretary of State because we had to, Mr. Freeman needed to do that. But I have already found a lot of stuff. And Mr. Norman, okay, since it is
motions.
We're
here about motions, not evidence.
Okay.
I said we're here about motions.
I would hope that this process and you as a commissioner and everybody are wanting this process to work for citizens that bring forth things that involve $300,000 of what appears to be unreported corporate spending that went through Constant Content. I would just ask you that this commission is not a court, and you need to think that you have to be here to serve the Ohioans that come forward, not just the attorneys. So the fact that disadvantages that you try to put people at and the way you react to them here is, I think, something you guys should examine. But on this particular thing, I've already pointed out your rules specifically talk about discovery subpoenas. I've provided with 14 pages of instruction by the director that I had to do a subpoena that would be issued by the commission, not me. I'm asking something very simple here, is that Mr. Bray should show good faith in responding to the discovery request. It's indicative of that we're so far into this process and so much is dribbled out that we're still at a point where Mr. Bray clearly doesn't want to clear up these issues. So the only way it's going to happen is because you guys compel him to respond. Otherwise, we're going to be sitting here 6 months from now going through circles on responses to discovery. Thank you, guys.
Mr. Hicks, is there a reason you didn't serve what we call civil rule request for production of documents and interrogatories upon counsel?
Yes, because Mr. Norman, if you looked at my filings, you would know that I provided you 14 pages of emails from your own director telling me to do it as a subpoena through him.
That wasn't my question.
I was instructed to do, and for you to sit here, frankly, it becomes a joke to me that citizens cannot access their own elections commission because they get railroaded by attorneys and board members talking to me as a citizen that came forward about civil rules when your director told me that it needed to be done as subpoenas. And this has nothing to do with all the legalistic mumbo jumbo. This is all about Mr. Bray not wanting to respond. Everybody else responded to your subpoenas. If I were you, I'd be wanting to say, as a commission, we don't want to have our time wasted, not by me. Mr. Bray can talk about me sending emails, and I'll keep doing it and releasing the audios of him to correct a false record. None of that would be happening if Mr. Bray would have simply responded in good faith to the subpoenas. It's of his own doing, but I'm glad to make these issues get surfaced, not just here, but in Ohio, about what happens when a citizen brings forward $300,000 of clearly spending that took place, labeled as being done by the campaign, with the campaign having knowledge of it. You guys should be outraged that now they know that they had knowledge and they filed something to Secretary of State. I know that doesn't relate to the motion right now, Mr. Norman, but I would hope there'd be some passion for finance integrity, especially what has gone on in Ohio in the last year. That's why I think it's important for you guys to make a statement that our rules say that talk about discovery subpoenas, and this is a lot of dilatory tactics on the part of Mr. Bray. And Mr. Bray, we as a commission think you just need to respond. Okay, if you guys then need to address how your director tells citizens to do it or emails saying how to file it, then don't penalize the citizens for that. Get him to respond. But frankly, he should be on this call saying, I'm going to respond in good faith. That's what everybody else did. That's what Ron O'Brien did, even though I disagree with the way it was.
Mr. Hick, my question to you was, did you ever serve a Civil Rule 34 or 35 request for production of documents and interrogatories upon his counsel?
No, because your director, before you railroad me in a yes, no, because your director told me to do it as a subpoena. And I'm not going to change that until you as a commission address this issue of your specific instructions to a citizen on how to do it in 14 pages of emails that so 4 months after it was done, the way that I was told to do it by your own director in writing, signed by him. Now it's like, well, let's figure out a way to stretch this out. That's what I'm talking about, Mr. Norman, about you guys should be outraged that Don Bray is even using these tactics. Everybody else, it would be fair, like Ron O'Brien. We disagree with the way that this is served, but we're going to go ahead and do this. If you guys need to clean up your own operation in terms of what you're telling people or what the rules that have to be followed, that's for you to do. I did what I was told by your director. And I believe it's supported in your rules. Your rules themselves, apart from the civil rules, make specific references to how discovery subpoenas are supposed to be done. So I'm just saying, we're sitting here with me getting nothing from this guy on this. And I know we're here to talk about the specific motions, but you guys as commissioners should be outraged that it's because this system can't work this way. It cannot work this way where high-priced lawyers come in and railroad, paper up, keep filing stuff against citizens, and just operate in bad faith under some argument that it needs to be done just this way. When you can sit there straight face talking to you guys, when he at the same time, his client is filing things acknowledging in disagreement with an affidavit that was filed to you in December, acknowledging, yeah, we knew there was $290,000 of spending that was done on behalf of our campaign. We were just told to ignore it. So I apologize for going off on the side, but frankly, you guys should have passion about integrity of finance in the campaign system in Ohio, because if people don't feel like they have to be honest with you, if people feel they can use these tactics to subvert your own subpoenas issued by your own director, where does that leave us in Ohio? We need to get this fixed. We need to have an elections commission that people respect and have respect for when they're asked to do things through that commission.
I move to deny the motion to compel.
There goes Ohio.
Otto, you're muted.
Before we take that motion up, does anyone else have any other comments or questions? I don't think that this requires Attorney Bray to respond. I believe his first statement touches on these particular issues.
Yeah, Mr. Chairman, I have a question of our executive director. Phil, it seems like Mr. Bray's argument centers on that the subpoena was improperly served and issues surrounding the subpoena. I'd like you to weigh in on that. Was the subpoena improperly served?
Well, I think what Mr. Bry's argument is, and if I screwed up, I apologize for making mistakes. But regardless, I think what Mr. Bry is essentially wanting to request is, in lieu of direct contact to his client as the respondent, to have the request come through him. And that's his argument, I think, primarily against the nature of the subpoena that was issued. But that he would then respond if a request for production of documents and other materials was provided to him in lieu of being in direct contact with his client. I could make other comments, but I believe that to be the case, and I think that's what it comes down to at this point.
I think it goes one step further. When you're responding to civil discovery, if you are opposed to producing documents, and whether it be an interrogatory or a request for production of documents pursuant to the civil rules, you have the opportunity to object to those as to whether or not they are relevant or for any other reason. And on top of that, you can seek to have a protective order. It's different as it relates to a subpoena because you cannot unilaterally go line item by line item. You would have to file a motion to quash the entire subpoena. And as it relates to parties to a civil action, if you are a party to the case, you can't serve a subpoena pursuant to the civil rules, which govern how we act on the Ohio Elections Commission. You actually have to follow the Ohio civil rules.
Fair statement.
So here's my struggle, and I'd like to somehow get some kind of resolution so these parties provide discovery to each other. I think that as I read our administrative rules and the rules that apply to the commission, there's without question, the Ohio Rules of Civil Procedure apply as it relates to discovery, and they're specifically incorporated into the administrative rules. And Mr. Hicks, I understand your frustration, but the problem is when we have pro se litigants in any administrative proceeding or court proceeding, we try to be flexible, but they are still required to follow the same rules that everybody else is required to do. And Mr. Bry's frustration, I think what Mr. Norman is saying, because he is a litigator himself, is that there is a certain process that has to be followed in discovery where you cannot just subpoena discovery documents. And the subpoenas that you're referring to in the administrative rules are about subpoenaing witnesses to hearings who are non-parties typically. Mm-hmm. So it's a very out of extraordinary and out of rule process that you are following. And if there's a frustration because you feel like you've been misdirected, I think the commission needs to try to get the parties to the point where they're going to provide each other discovery somehow. Mm-hmm. So I don't want to be, I mean, he does need to follow the appropriate process on the one hand, yet on the other hand, we do need to get these parties to a position where they're providing each other discovery before we can set this matter for a meaningful hearing. So I appreciate Mr. Bry's approach because he's trying to follow the rules as they apply to this commission and every other tribunal in a civil proceeding in the state of Ohio that follows the civil rules. And that would be that you cannot just subpoena his client, that you actually cannot just contact his client, that you are required to go through him because he's represented by counsel. Because you're not represented by counsel, he has to contact you. And I think he's feeling some frustration because he's trying to do what lawyers would typically do, which is they're required to work out these discovery disputes among themselves, which clearly neither of these parties can do. So I guess I look to other members of the commission to see if we can get some kind of a resolution or have discoveries submitted through us or something to get these parties to provide each other with relevant discovery and to have a forum to be able to object to get it done. I'm at my wit's end about how to make that happen because I've read all of the motions and all of the pleadings and they just go on and on about the frustration everybody has with each other. So I am open to suggestions about how we get that done, but I think that just, doing a blanket denial of motions and motions to quash and subpoenas and all of that does not help in getting this case moving forward on the one hand. Yet on the other hand, Mr. Hicks, just because you ask us to issue a subpoena and we do, does not absolve the fact that somebody has the right to argue about whether the subpoena is appropriate, which Mr. Bry is doing. Just because we issued it doesn't mean that it's not subject to challenge. It is. And so somehow we've got to work through these things. And I don't know whether we can work out a resolution today. I think that asking the executive director to do it at this point is unfair because I don't think he's able to do that either. So I think it's going to have to be the commission who acts to do that. And whether we need to do it today or whether we just need to take it under advisement and have it at our next hearing for decision, that may be something too. So I'm just throwing that out there. I'm not looking for any response by the parties. This is discussion with my fellow commissioners I don't have a great solution, but I feel like as a commission, it's our responsibility to do something to get these parties to move forward and provide appropriate discovery through each other, through the appropriate means that are clearly adopted in our rules.
And what I would prefer to avoid is Mr. Richter as the executive director to the Elections Commission now becoming personal counsel to these pro se people who are going to potentially rely on him to be their counsel. And that's not his role. His role is counsel to us as the commission, and they don't understand or cannot follow the rules, then it would behoove them and it would be in their best interest to retain counsel to represent their interests. And so what I don't
You're frozen
want is
for me.
thrown in front of the train to have to be involved with that every single time, because that's not his role and that's not his responsibility.
Agreed, which is why it's before the commission right now. We usually, it's unusual for the commission, Mr. Hicks and Mr. Bry, both. It's unusual for the commission to get involved in discovery disputes. And when we do, it's because it's gotten relatively extreme and we need to do something as the decision-making tribunal. So that's why I agree with Mr. Norman. I don't think that we can, the executive director has the authority to resolve these issues and we typically rely on him to do it. But in this case, I think it's gotten beyond that, where the commission is going to have to step in and act as a body. And it's unfortunate, but I think he has the ability to refer it to us and has, because of the difficulty of the parties. So I agree.
I'll just interject and say I'd have no problem trying to work between the parties. It wouldn't necessarily be an easy thing to do, but yeah, it's a matter of working between. I've done it before, but I'll just throw that out there. I appreciate your comments, Ms. Cunningham and Mr. Norman.
I'll take another comment, but I do want to keep in mind that we do have a commissioner that I cut him off, but he intends to make a motion. So I'll hear any other comments from other commissioners, and then I need to allow the Commissioner Norman to make his motion.
And I think I've already made my motion. And for me, it just seems it's about an easy solution as possible, which is don't rely upon your subpoena, which the civil rules do not call for. Mm-hmm. Civil Rule 34 and 35 requests upon Bry, and then you get your responses, you get your objections. And then if you don't like what you see from that standpoint, then you bring it back before the commission. But it just seems to me that the civil rules are patently clear that you serve a subpoena upon a party. You need to follow the rules. And if you don't want to follow them, that's fine. You don't get your documents. But it seems the motion to compel is why I moved the motion, because the civil rules don't call for it. You can't subpoena.
Okay. At this time, I would ask that you restate the motion.
Yeah, I moved that the commission move to deny the motion to compel.
Is there a second? I will second that motion. Okay, given that there's a motion and there's been a second, may we proceed to a vote?
Yeah, I'll do a roll call vote. if that's appropriate for everybody. Mr. Bromer,
No.
Ms. Cunningham,
I'm going to vote yes, but I want to say to Mr. Hicks, I think the process, if you follow the right process, you'll get the discovery. And you're entitled to the discovery. But I think the process of the subpoena is the wrong one, and to compel a subpoena is inappropriate. So I'm gonna vote yes for that reason, but not because I don't think you're entitled to some discovery.
Ms. Kaufman,
No.
Mr. Norman,
I'm going to agree with Commissioner Cunningham and say yes, and I have concern not pass. We have now violated the statutes of the state of Ohio, which says the Ohio Commission is subject to the Ohio civil rules as they apply to us and they apply to discovery. So I think we may have a significant issue.
Mr. Beatty,
I vote yes for the motion.
well, the motion still fails because it requires a vote of 4 persons. For the commission to do anything, it requires a vote of 4 persons to move the matter forward. So the motion is still out there. It hasn't been denied. It also hasn't been approved. I mean, I guess I could say, I guess I would interject and say, I'm willing to try and work through the parties to try and see what can be accomplished. If Mr. Hicks and Mr. Bry want to discuss, what it is that needs to be, what it is that can be provided, what it is that will be provided, what it is that will be objected to, and we could presumably present it back to the commission at a subsequent meeting, or maybe it complies with what is, what needs to be provided, as well as dealing with on the other end of this, the motion to quash in terms of what Mr. Bry is trying to get, and primarily, I guess I'd say in terms of a deposition.
So let me ask you, Mr. Richter, do you believe my statement was accurate, which says that the Ohio election is subject to the Ohio civil rules, which requires, as it relates to a party, that you cannot serve a subpoena, but you have to serve civil Rules 34 and 35 discovery requests to get the information being sought? Claimant in this matter?
The civil rules are a part of our, we're incorporated as a part of our administrative rules, and so we are subject to those, yes. Now, again, I was requested to help Mr. Hicks, which I tried to do. I was informed that subpoenas that he wanted to issue subpoenas. I provided him with formats for those subpoenas. He submitted the persons to be subpoenaed. Maybe I should have looked more carefully, particularly as it relates to Mr. Freeman, but I was requested to issue subpoenas. I issued subpoenas. Maybe I could have and should have done more as it relates to clarifying that particular issue. I did not do so, but I don't know that that's not, I don't know that that's an unresolvable issue. If we try and work through what might be considered more standard requests for production from Mr. Bry's client, and also Mr. Hicks' willingness to provide what Mr. Bry is requesting.
Well,
So
I'm gonna,
I'm sorry,
Catherine.
I'm sorry, Scott.
I didn't mean to interrupt. Go ahead.
Just for Mr. Hicks, and Mr. Bry, our administrative rule 3517-1-09 starts out specifically in subparagraph C, says that you are required to follow the civil rules, and it calls them out. Mr. Bry was talking about them. They're available on the Ohio Supreme Court website. It calls those rules are called out. They make very clear distinctions between what you can do if somebody's a party and what you can do if they're not a party. Mr. Hicks, I appreciate your comments relating to some of these other people who were cooperative with you, but they were not parties and they were subject to different rules than a party is. So I sort of direct everybody's attention to that as you move forward to try to follow those civil rules and do as they say. And if you cannot resolve these, and Mr. Hicks, you are entitled to discovery. There's no question about that. Nobody in this commission is saying that you're not. It's just that you need to follow the rules that we as a commission are obligated to follow in enforcement. And if the parties are still unable to resolve it, you'll be back before us and, hopefully in fairly short order to get that resolved. But I just don't know what else to do other than to sort of direct you to the rules and try to make sure that everybody's following the same rules that appropriately apply and are required by our own rules to be applied by us in this case.
And I'm a trial lawyer, so I deal with these rules all the time. I guess my question is to both Mr. Bromer and Ms. Kaufman. Have our comments discussing the fact that we are upheld to follow this Ohio civil rules, and from indications that they were not followed, does that change your opinion at all?
No, it hasn't changed my opinion, or my vote, I should say. So far, there hasn't been a declaration one way or the other here. We are at a point where we didn't have enough to carry the vote. To me, that's a compelling reason for the parties to sit down and work this out. Mr. Hicks, you've heard all this. You certainly know what's in front of you, and Mr. Bray the same. I just think with Mr. Richter's help, maybe all this becomes moot. You get the information that Mr. Bray's willing to give. And when you come before us again, we'll make the decision then whether or not you are entitled and how it prejudiced your case by not getting this information. In a former life, I used to do a lot of labor arbitrations, and I used to make sweeping requests for information. And the employer's attorney would always say the same thing. I think you guys learned this in law school. And that is, overly broad, overly burdensome, and I forget the third, but in any
That's
event.
101.
Yeah, but in any event, we worked through it. And the arbitrator gave my objections the weight he thought it deserved. And I think the same will happen with this commission. You'll get as much as you can get. And if you make a good argument, then we'll give it the weight we believe it deserves.
Well, the problem we have is we have a motion that's pending now before our commission, and there are sufficient votes to rule on it. And so we still have a motion pending, and we still have
You keep breaking up, Scott. I'm not sure why. And so we're not getting a consistent message from you. Just to back off a little bit and say, give you an opportunity to restate what you're saying.
Let me try again. Is this any better?
So far.
Yes.
Okay, so I filed a motion to deny the motion, which did not pass. So we still have a motion pending. And I suspect if we don't have a ruling in that motion, we're going to the next time this is called before us, and we're going to be in the exact same position. We're the same foot in the same spot.
Are
Mr.
you
Ray.
addressing that to me, Scott?
No, I was just addressing to the commission in general.
I mean, it could possibly end up that way or not, depending on the actions of the parties before we sit down again.
We've seen the actions of the parties now for a year, and nothing has taken place. All it would require would be for Mr. Hicks to follow the civil rules, make his 34 and 35 civil rule requests, and then we would actually have objections and or something to rule upon.
So, Scott, may I ask for clarification on this? So
Sure.
your motion to deny is based on the fact that if Mr. Hicks would follow the civil request rules of 34 and 35, so we're denying it based on a subpoena, but if he would just, change courses, do 34 or 35, request it in that forum, then we would be able to get the information, they would get the discovery each of them is requesting. Therefore, it's not saying that you're not entitled to discovery. It's just the way we're going about it is not the way that's going to get it accomplished.
Absolutely, because as an attorney, you can't object to a subpoena, but specific request for production of documents and interrogatories, which is a fancy term for questions, you can object to those, and then you can reach out to the tribunal to have them rule whether or not you need to answer those. But you can't object to blanket portions of it. You have to object to it as in its entirety.
Sure. Then based on that, if we're just asking Mr. Hicks to change the way that he's requesting the information, then I would say yes. I would agree with the motion as you set it forth, because I think that further discussing this and Mr. Hicks having the opportunity to hear this, to say, listen, maybe that's the way it was originally presented to you, is that it needed to be a subpoena at this point. Listen, let's do it as what it's, as it's listed under civil, rules. Then I think maybe Mr. Hicks has a different perspective on it as well and could, move forward in the direction that we're directing him to go. Does that make sense? So in that way, I would agree. Yes, then I would vote yes to deny the motion.
And Commissioner Kaufman, I would say part of the reason for that, and I think what Mr. Norman is trying to sort of explain, is when you do it that way, it's not an all or none.
Right.
If there are some things produced and some things that aren't, when it comes back before us, there is a narrowing of scope where parties can say, I asked for all of your birth records and I asked for all of your divorce records, and you only gave me the divorce but not the birth. And then we say, okay, is that relevant or not, or how does that fit in? And it allows the commission to at least identify what the issues are. And as Mr. Brommer says, we're going to listen to it and we're going to not, and somebody's going to decide based on what's before us. In the sort of the way that it's come before us with just these blanket subpoenas, there's not really the ability to do that so much. So it's just to sort of get the parties to follow the process so that we can hopefully be of assistance to them if they cannot work it out themselves.
Right. And I would hope that Mr. Hicks would recognize that, we as a commission are really trying to make sure he gets what he needs.
Right.
By changing courses and changing the way that we request the information doesn't mean that the subpoena route was wrong. It just means that there's a better way to go about it. We're acknowledging that now. Let's all work together to make sure that we're doing things in a manner that will make everybody more accessible.
And I just think if he follows it. Go ahead, Dennis. I'm sorry.
Well, let's ask Mr. Hicks. Having heard everything you've just heard, would you be willing to withdraw your subpoena and then ask for the information along the route that was suggested?
I think that what should be done, if we were working in good faith, would be for Mr. Bray to do what the other people did, like Mr. O'Brien, and say, I object to the way this was served, but these are the parts that I will respond to. That's what Mr. O'Brien did, right? And you saw Mr. O'Brien and me work that out and no issues. So this is what I fear, Mr. Bromer, is that I think, Mr. Norman, you said we're a year into this, right? Okay, so we're a year into this, and what's going to happen, I think, is if I do it a different way, so I acknowledge what you're saying, it's going to be more stonewalling, more stretching it out, everything's an issue. And again, I came back to the statement that, you need people to operate in good faith. So I think, I hear what you guys are saying, okay? But I think a better alternative would be for Mr. Bray and for this commission to ask Mr. Bray politely to say, Mr. Bray, can we agree that the way that you can respond like Mr. O'Brien did and said, I believe this was done wrong, but these are the parts I will respond to in good faith. That's what Mr. O'Brien did. I don't understand. I don't want to go through stretching this out. Frankly, I think I have a lot of evidence right now, and we're in about how much spending took place, how it was. So I think I don't want this to get delayed too much. What I would prefer is if Mr. Bray would do that in good faith, And by the way, it's also not been said, I already provided Mr. Bray every piece of discovery I got from every other party. So I already provide, so when we say like, I haven't been responsive, I already provided stuff in good faith. So I would put forth the idea that Mr. Bray would just agree that he will do the same thing Mr. O'Brien did, respond to those things that he feels are appropriate to respond to while disagreeing with the way it was served. And then I would also agree that I will do the same with the discovery request that he has served upon me. And I will be glad to sit for a deposition within the next 2 weeks before your next meeting takes place. So that's what I would agree to if Mr. Bray could be so kind to agree to do the same thing that his colleague, Mr. O'Brien, did, which is respond to those portions that he doesn't see as an issue while stating that he doesn't believe it was proper the way it was served.
So, Mr. Hicks, again, this is Scott Norman. If you were to submit your requests pursuant to Civil Rules 34 and 35, and I believe Mr. Bray has already said he's the template to do that. You can do that and you can submit requests and they would have to be provided to you within 28 days. And if that were actually done, then we as a commission would have the teeth pursuant to the Ohio Civil Rules, if he doesn't comply and he doesn't provide what's available, to actually take action. But as it sits currently, and again, I'm a practicing lawyer and I follow the civil rules, submitting a subpoena on a party, we as a commission can enforce. So what I'm trying to avoid, and I think what we as a commission are trying to avoid, is having this come back in 30 or 60 or 90 days and we're in the exact same position. It seems to me it wouldn't be that difficult for you to make your requests based upon what Mr. Bray has already provided you pursuant to Civil Rule 34 and 35 to make your requests. And then if he doesn't give you what you want or what you need to seek, then you can come back before us and say, he's stonewalling me, he's hiding it from me, he's not doing it, because then you have followed the rules. It seems to me that it would be in your best interest to proceed in that fashion.
So if I can respond, it seems to me that it would be very easy for Mr. Bray to just say here, he will respond like Mr. O'Brien did, that he disagrees with the way it was served, but these are the portions that he will respond to. So Mr. Norman, so it doesn't even have to come back before you. Okay, so it doesn't have to go through this process. Remember, this is was scheduled for full hearing on July 15th. Okay, on July 15th. I've requested that be put back 1 month. Okay, and so we can do the argument on his motion to dismiss. But again, I have to come back again and say I followed the instructions of Director Richter. So I think you need, as an attorney, to understand. I have a lot of attorney friends. And they seem to understand the idea that we got to be working in good faith and we can't let things just drag out. And we could solve this very quickly right now if Mr. Bray would simply agree that he's going to respond in the same manner that Mr. O'Brien did, with saying, I disagree with this, but here's what I will provide you. And then I will do the same with his discovery request. And then it never needs to come back before you guys. It's that simple.
Just so we're clear, Mr. Hicks, and again, I'm a practicing attorney. As it relates to a subpoena, you can't go line item by line item and object to what's in a subpoena. You either produce it or you do not. As it relates to a party, if you serve the request for production of documents and interrogatories, you then have the ability to say, either I think that's inappropriate or it's appropriate, and I respond. And then we as a commission can respond to that. They are two completely different vehicles, and there's a reason they're two completely different vehicles, and that's why the rules were developed that way. And so if you want to continue to argue with, not necessarily me, but us as a commission, and you want to continue to say Mr. Bray has to respond to a subpoena, I think you're not going to get.
I continue to ask.
Let me finish. Let me finish. I don't think you're going to get it any further down the road. But
okay, that's fine.
If you were to submit your requests, I think it pushes your case further, and then you can put forth before the commission whether or not you think they're being forthcoming and acting in good faith and providing the documents to you. But we're not at that stage.
Can I ask a question, please? Mr. Bray, is it possible, given the format of what you received, if it was converted to it could be converted to civil discovery? I know there was some comments about you even sent him a template and all of that. Can you address that issue and Mr. Hicks's request to the commission? I agree with Mr. Norman. If it's in this format of a subpoena, it's a different thing for all of us.
Yeah.
So
you can cut and paste what he has. I think it's overbroad, but I'll object to some things and we'll produce other things.
Stretch it out.
But I sent him a request for production of documents in both original form as well as WordPerfect form, so or Word form rather. And so he can take the Word form, change the caption, delete all of my requests, put in all his requests, and send it back to me. He could have done that a couple months ago.
And
we
you
will
could have just
respond.
sent back something. You could have done the same thing Mr. O'Brien did months ago.
Well, we're
Okay.
party. He's not.
You're
And by the
just,
way, I
this
was
is
his
just a
counsel.
stonewall. This
Mr. Hicks,
commission is
Mr.
a
Hicks.
joke in Ohio. Okay,
Mr.
how are
Hicks.
we ever going to have campaign finance integrity in Ohio?
Mr. Hicks, you
When
have to let people finish speaking before you start.
Okay, well, I'm sorry, but this, I think it's just, I love that this is exposing what a joke this is in terms of having it, and why we are the #1 most corrupt state in the country, is that this could have simply been good faith. It is absolutely absurd that that nobody seems to have an issue with Mr. Bray doing nothing in good faith and wasting your time as a response in this process thus far, and has done nothing to disclose anything, and is going behind the back while there's a hearing going on in the Ohio Elections Commission to file things backdated into the Secretary of State. This is indicative of what's wrong and why this type of commission needs to be reformed in some way. I hope you guys think that, in order to have it be more responsive to citizens that come forward versus protecting the very people that it's supposed to be regulating.
Mr. Hicks, I'm going to try one more time. I am not a lawyer. I am a former labor leader.
Okay.
And one thing at the bargaining table, I was always told to read the other side of the table. And what the other side of the table is telling you right now is they believe you have a right to discovery. They are supportive of you. I am supportive of you. All they're suggesting, and because I'm not an attorney, I do defer to the other members who are attorneys. They certainly have practices more than I ever have, and I haven't at all. They're telling you something. You can get the discovery you ask for.
Mhm.
Why aren't you willing to do that?
Because this is just a stall tactic. I'd like the hearing to go forward on July 15th, the full hearing, and let's just do it. Let me bring in the evidence that I already have on the $290,000 while Mr. Bray sits there and explains away this stuff. I don't want this to keep getting delayed. This is an affront to the people of Ohio, where there was blatantly $300,000 not reported that they acknowledge. And I don't want to just keep stretching this out, Mr. Bromer. So read my side of the table, okay? Read my side of the table. I believe that there was a criminal activities took place here, the same on this side as took place on the Growth and Opportunity PAC side. I hope you guys would be concerned with that. It involved $300,000 in a primary for a House seat, okay? So I hope you'll read my side of the table, that I'm at this point wondering, what's the whole point of this OEC exercise? Okay, what's the whole point of this? So we can have a $100 fine at the end or something? There's serious matters here involving campaign finance integrity. And nobody wants to talk about that here, right? Nobody wants to operate in good faith when it's very clear Mr. Bray's role is that he doesn't want to clear these issues up. They could have cleared these issues up 6 months ago. Okay, but they won't clear them up. Now, I know that, Mr. Norman, I know that doesn't relate to the motions before you. That doesn't do this, but I'm going to keep making this point of this commission has a responsibility, in my view, to be passionate about campaign finance integrity, and should be very upset about attorneys, high-priced attorneys that come before you all the time that clearly are trying to stall and stretch out anything happening. So you currently have a full hearing set for July 15th. Let's do it with what I already have.
Well,
Is that okay with you, Mr. Bray? Let's just do the full hearing in Columbus on July 15th. That was the way it has already been scheduled. We can just forget about all this and I'll present the evidence that I have.
What, forget about you responding to my discovery? Forget about me deposing you? Forget about getting the documents that you intended to produce?
Also, now here's another way to stall. You should be wanting me to come in without any information, with what you believe is not information. You want it both ways. We don't want to have the hearing. So let's just do it. It's currently scheduled for July 15th. I'd like the full hearing to proceed on July 15th.
May it please the commission. I think there may be a practical way to resolve the discovery stuff, but I think you've probably seen that there might be challenges, even if Phil Richter is involved with trying to sit down and negotiate.
Right, your
something.
stonewalling will be a challenge.
He interrupts people. He accuses them of stonewalling. All the rest of it. You've seen it. You've heard it. You've read it. I
Correct.
think what a practical solution might be to instruct him to, if he wants discovery, to use a Rule 34 and issue it within the next week. We will respond within whatever it is, 28 days or whatever.
I withdraw my
And
request for
also,
discovery
I'm not
from-
done speaking.
I
And
withdraw my
also
request for
to
any
allow
discovery
him,
from-
but to require him to respond to our written discovery within 2 weeks after that, after we respond to his. So he can't complain about the fact that we're getting a response before he does, but he will be, I would suggest it would be appropriate for the commission to see if you can get his commitment to do that. And that may take care of the motion to quash, which I don't think has been ruled upon yet.
I will be glad to withdraw my request of discovery for discovery from you, Mr. Bray, and Mr. Freeman, under the condition we proceed with a full hearing on July 15th.
Well, I do need discovery from Mr. Hicks.
I'll do whatever you
I'm
need me
not
to
gonna
do in
go
the
into
next
hearing
five.
without proposing.
So I will respond to your discovery within 48 hours of what you've already provided me, and I will sit for a deposition with you any day next week so that we can move forward with a July 15th full hearing so that we can get this matter out there before the public, so we'll just resolve the issues that way. That's good for you?
So wait, I want to make sure we're clear. You're withdrawing your motion to compel. And so you're not requesting discovery upon Mr. Bright, is that correct?
Correct.
All right.
I
And
withdraw the subpoena, okay? So
all
I
right,
withdraw the discovery. that I
Mr. Hicks, let me
submitted
finish.
thus
I want to
far.
make sure we're clear. I know Mr. Bry has submitted discovery to you.
Mhm.
When did you provide that discovery to Mr. Bry?
I'm sorry, you broke up.
I said, I know Mr. Bry has served discovery upon you. When can you produce that to him?
I would hope to produce by the end of this weekend. I could produce it. I already gave him all the documents he asked for. That's what he doesn't tell you.
Well, I'm not involved in it. I just want to make
Okay,
sure.
so it's not a big deal. So I've operated in good faith throughout.
Mr. Hicks, then you mentioned that you would be available for depositions anytime. I'm going to ask Mr. Bry to look
Obviously
at his.
not anytime, but yeah, I'll be, Mr. Bray, if you have a date you want to depose me,
Okay.
but let's do it via Zoom, so it's easy for everybody. Not
While we're
making
sitting
me
here,
come
why
to
don't we pick a-
Columbus.
You had set a date next week. Why don't we look at our calendars and see who's available next week?
Okay. I am generally available next week. Tuesday, Wednesday, or Thursday of next week would work for me.
Hold on one second. My,
We're talking about June. Well, hopefully they will. Let's see.
And Don,
June
while you're looking at
29th,
that, can you
30,
give-
or July 1. Pardon?
Can you give him an understanding approximately how long the deposition is going to take so he can have it blocked off?
I think probably take all day, quite frankly.
Okay.
an
I was
all-day
just checking.
deposition to me. This is just what he tries to do. He tries to monopolize my time, get me to come to Columbus. I'd be willing to give you a couple hours, Mr. Bray, but this all day, come to my office. You just saw Mr. Norman the way that he acts. It's
Mi-
monopolize
Mr.
my
Hicks?
calendar.
Mr. Hicks, he just said he's willing to do it by Zoom. And he said he thinks it's going to take a day. So you're not going to have to Columbus. You're going to have to click.
I don't see any reason why I would need to sit. I've had a couple people deposed in my life. None of them have been that long over this matter. Just see the ridiculousness of this. He went to
Mr. Hicks?
tie me up for an entire day.
My,
No,
Mr.
I'm
Hicks,
not gonna
I
give
just
you
had
a
one
whole
on
day.
Tuesday that went all day.
my
Okay.
expectation is that his responses will be not short. And you can judge from watching him whether my expectation is a reasonable or an unreasonable one.
Okay.
So Mr. Hicks, expect you're going to have a day. Which day works best for you next week?
I can't give a whole day next week.
Okay.
So
Well, how
if
about
about
Mr.
the
Bray
week
would be
after
willing to accept, I'll go to a half a day. Okay, but I cannot do a whole day next week. And I just want to point out, this is what happens to a citizen when they bring forward something that's a problem in our campaign finance.
I'm just trying to bring the
I
parties.
know, I agree, I appreciate that. But the
how
full
about
day,
the following week? Would Tuesday the 6th or
so
Thursday?
you can't
the
do
8th?
anything at a half day. We can't do a half day and then you determine whether you need to do another half day or whatever the hell.
I'm not going to make it last longer than it needs to last. If we get done early, we get done early, but I'd like to have the whole day.
So what
Just-
day,
Don, maybe
what
as
day
a,
next week can we do 4 hours, Mr. Bray?
Pardon?
Mr. Bry, maybe as a concession, we pick 2 half days.
Yeah, we can do that.
Pick your 4, and then the next time pick another 4 in case you don't finish.
I think that sounds fine. And I think that sounds fine. And the first 4 certainly will be by Zoom. Hopefully the next 4 will be by Zoom.
All by Zoom. All by
If
Zoom.
I want to have it in person, obviously we're going to have some more communications with the commission because Mr. Hicks' facial expression suggests that he won't do any in person without fighting about it.
Well, I just want to witness it. Mr. Bray, he had 4 requests to me for depositions. They tend to be things intentionally designed to inconvenience me, not to get at anything, you know, of any depth. But so, Mr. Bray,
Well, Mr. Hicks, as a trial lawyer, I will say sometimes when you do a deposition, things get lost when you're looking at a video screen as opposed to being in person. So there are reasons why let me finish. Let me finish. There are reasons that we trial lawyers like to actually have this in front of us. I understand that you're not in Columbus and we're trying to be as accommodating as possible, but it doesn't seem to me that you want to be accommodating at all.
I'm the one who's already provided 200 pages, and I'm the one talking about depositions and trying to get something scheduled with the guy. So, Mr. Norman, it's bullshit that I'm not the one being accommodating. Okay, so Mr. Bry, what's a day next? I'm the one who proposed what we're talking about. Okay, what's a day next week
Mr.
for
Ricker,
4
I'm
hours?
going to mute myself and would ask that you maybe step in and take over this as opposed to me.
I'll be glad to try. I think that, you know, it's a matter of trying to work through the process here. I think Mr. Bry is looking for a day or requesting a day based on the nature of the responses. And if the responses come back, I don't know if I want to say short or brief, but to the point of each question asked, it gets done a lot earlier. And I think his, you know, the acknowledgement that maybe 4 hours each day next week, he talked about Wednesday and Thursday of next week, maybe only Wednesday is necessary, depending on the nature of the questions asked and the responses given. And I would certainly encourage doing that in order to move this process along forward.
How about the 6th or 8th of July? We're trying to get.
No, I thought we wanted to do it next week. I thought that was the whole point.
Well,
but
it was, but then you indicated, I'm sorry, Don.
One day out next
I
week.
indicated 4 hours next week and then determine what we need to do after that.
Right.
And to do another 4 hours. But then what Mr. Bray did was immediately say like, well, 4 hours here, but 4 hours in Columbus. Okay. So it's a slippery slope. So what day next week, Mr. Bray, can we do 4 hours and then you determine what else you need to do?
4 hours by Zoom next week. I've given you 3 potential dates. If
I keep asking, repeat them because I didn't hear them.
Okay, it's Tuesday the 29th, Wednesday the 30th, or Thursday the 1st of July.
The 29th.
Okay, the 29th it is. And we will have.
What time?
I don't know, want to do about 10 o'clock or 10:30?
Can we start early, like 8, so we can get done for the 4 hours? We don't break up the whole day.
I won't be caffeinated by 8. Yeah, I do it for the commission, but if I have a choice, at 10 o'clock, I'm fully caffeinated.
So hold on a second here. You won't do 8 by a Zoom because you can't get caffeinated?
Yep.
Okay, well, I would request the 29th at 8 a.m. via Zoom. You get your caffeine a little early, get to bed early, so I can get it. I'm a business person. I won't want to break up my day.
Okay, then let's do it.
So
Let's
do
give it the whole morning and start in the
8 to
afternoon.
noon on the 29th. Can we make
Let's
that
start-
work and you get some extra
How
coffee?
about 2 o'clock on the 29th?
2 till 6?
Yeah, or 1 till 5. I don't care.
Okay, let's do 1 to 5 then,
Okay.
on the 29th.
And then let's set up a tentative at least. We'll figure out the place. You know, because I think I probably will need to do it in person, and I know it's going to be pulling hen's teeth to get him to come to Columbus. I mean, you know, let's see if we can find.
It's not going to be pulling teeth. I'm not going to come to Columbus. You can come to me if you want to depose me. I have a lot of lawyer friends, Mr. Bray. That's normal that you would come to me.
As I said early on. So the question is there a particular location with one of your lawyer friends that will make their facilities available so I can come down and depose you in person the week of the 5th? Say
what
the
I'll
6th.
do is book a room at the Union Township Civic Center, which is by my house. They have meeting rooms that people can use in there, and we can just use one of those rooms.
Okay. Well, can we do that the 6th or the 8th?
Let's do. Hold on, I'm looking at my calendar. The 8th.
Okay. Then the 8th it is, same 1 to 5.
And if you want to do the one on the 29th in person, I'd be glad to do that in the Union Township. I can try to book a room over there on that. So the whole Zoom thing was because me giving you an alternative other than coming to Columbus.
Yeah, I do, but I think I'd like to come there once rather than twice. So did I get July 8th right, in person? Yeah. And you'll identify the place. Is 1 to 5 still a good time period for that?
Yeah, because that'll give you time to get here, right?
Yeah. Okay.
Okay.
I think we've got them. I will withdraw the prior notices of deposition formally, so you don't need to move on the motion to quash. I think if you respond to the written discovery, the interrogatories and document requests in a couple of days, as you've promised to, that should take care of that. And I think that makes the motion to quash moot at this point. Am I correct or incorrect about that?
And Mr. Hicks, I suspect if you were to submit Civil Rule 34 and 35 discovery on Mr. Bry, that he would get those to you fairly quickly, maybe even in time for your deposition. That's a choice you're going to have to make.
Mm-hmm.
Well, the 29th is Wednesday. He already has, so that's why I was asking Mr. Norman, that if he was wanting to be in good faith, he could just say, of the stuff that was in that subpoena, I'll in good faith have my client respond on those things we're comfortable responding to. That would be good faith, working as humans, not as like legal.
Mr. Hicks, you've already indicated you're withdrawing the subpoena. I'm just trying to help you out by saying if you were to make those 34 and 35 civil rule requests, you probably would get the documents, but that's a choice you're going to make.
But I'm not going to get the documents before the. Are you committing that if I did that, Mr. Bray? I would actually. That's a great thing to bring up. That if I would do those as Civil Rule 34, 35 requests, you would get me the documents by the time I have a deposition on June 29th?
I doubt
if you'll do that, Mr. Bray, I'll be all about it.
Today's the 24th. I doubt that you will get me the request and that we will have a formal response to it in 5 days.
Well, when can you?
We're not going to drag our feet on it. We're going to get it to you in a prompt fashion. But no, I'm not
going to. Get it to me by July 8th, the second date. Can you get it to me by July 8th?
I hope that we can.
Okay. So
but I'm not going to promise that it will happen by then.
When can you promise it?
But I hope
by? You know what I'm going to ask. You've already seen it.
Let's not argue. Maybe what we should do is we should talk about when do you think you could get the 35 and 35 rule requests out? Could you do that by tomorrow?
I'll do that tonight before I go to bed.
Good. Okay, so typically it's 28 days. But if we gave Mr. Bry, instead of 28 days, we cut it down to 14 days. Should we then look at a new schedule for depositions?
Obviously, I want to respond to it before the hearing on the 14th, because frankly, we'd kind of like it to be over with too.
Well, what I would say is, hold on, I'm looking at my calendar.
I'm going to step out of the way then.
So today's
the 24th.
Okay. So that would
be.
So
the day is July 1 or the.
So that would be the 8th. The second deposition date would be 14 days if I get it out tonight, right?
That sounds about right. Yeah.
So what'd you say?
Obviously, if you ask different questions, that estimate may vary. But yeah, we'll try to get them better.
Okay, so I'm going to add the same things that were in that subpoena because it's not going to be different. So I would have that by the if I do that by today, 14 days is the 8th. Okay. Mm-hmm. Then I would request, because now we're actually, meet before saying the full hearing on the 15th. I would just ask that we postpone the full hearing by 1 month to an August date, because obviously if we're going to start doing this stuff and getting discovery and depositions, there's going to be things to digest. And that would be, then I think we could be hopefully ready to move everybody ready to move forward.
And Don, can you put on the record that you think you can reply? I mean, I understand it's 14 days, but quite frankly, to be fair to Mr. Hicks, if we could reply in 13 days, so he has it on the 7th, so he can review it before his deposition, I think that's fair.
We will make, I mean, I hesitate to use the term good faith because it's been used and misused here, but we will make a good faith effort to get the responses to him by July 7th.
And it seems to me that we should then maybe postpone the 29th date of June, because you won't have the documents at that stage, and maybe look at June 8th or July 8th being the first, and then the second date after July 8th, so that Mr. Hicks has the opportunity to review documents before he has to testify.
Well, the 29th one is going to be by Zoom. And
I appreciate that, but he's not going to have June 29th. He won't have the discovery requests yet. And so it seems to me that if he's getting the discovery on the 7th, he can review them, prepare for sometime on the 8th, and then set another date between the 8th and the 15th.
Well,
for his second round.
Okay, let me put it this way. If you're already gonna kick the July 15 date, then that makes sense. If you're not gonna kick the July 15th date, that wouldn't make sense.
Well, I think Mr. Hicks has just asked for it to be bumped so the discovery can be completed and he can look at documents.
Well,
And I don't wanna speak-
that actually, I mean, I defer to you. I don't care. I mean,
And I don't wanna speak-
as a practical matter, we probably need to thrash out the discovery a little more before we have the hearing. I understand that. And so, and if the concern is that by the 29th, he won't have the documents, which he won't, then let's see what other date we can find.
And Mr. Hicks, I don't want to speak on your behalf, but it sounded to me if you're going to be deposed and see these documents, you wanted to move that July 15 date to either the August 12 or August 26th. Is that fair?
Correct. The full hearing date, yes. I don't,
Yeah.
yes, absolutely.
And I didn't want to speak for you. I apologize.
Okay.
Are
Okay,
both
if
parties
it's being
available?
moved, then we can kick the deposition dates down. My concern about moving it was primarily getting it done before the hearing.
No, and
Brian.
that's why we address it.
Mr. Bryan, Mr. Hicks, are you both available on the, Phil, I guess I should ask you which date? August 15 or August 29?
I think it's 12 or 26, isn't it?
Yeah, August 12 or
August 12.
26.
We are available on either date.
Phil, I don't know what his agenda's like. Do you know yet?
Hey, we can make either day work.
I believe
Gentlemen.
I can make either day work.
12 isn't quite a month, but you know, it's close enough.
I'm going to suggest the 26th. That gives you a little bit of leeway to be able to resolve any disputes.
Right.
So, okay.
Mr. Bray, would you like to, if you're, now that we're at this coming to, and me booking a room in the Union Township Civic Center for a deposition, in a sign of good faith and flexibility, would you like to, if you want to do something in person at some point anyway, then I would agree to do the full day if you come here and do one trip for you here, and then do a full day deposition. We can start to give you time we can start to give you time to get here, so it's not so early.
Appreciate
Okay, but and then I'll go as late as you want. Is in that on that?
I think that sounds like a fair plan. I appreciate your consideration. I come down to Cincinnati. We do a full day on July 8th, and we're done.
Well, what I would say is, why don't we do that? Because of the request to give everybody some leave, or do it like early that following week, like the 12th or 13th. Then I don't.
And Don, you can caffeinate on the way down.
I will, trust me.
If we did around the
Yeah,
12th or 13th, then I'll have
would
time
work
to
for me as
get,
well.
I'll have seen the documents. Mr. Norman makes a good point. Have time to digest them.
Okay, so say July 13th.
I think he said the 13th.
Yeah, I think that's good. Does that work?
13th, okay. And then I will, here's my question to you, Mr. Bray.
Mhm.
A lot of your discovery requests on me asked me questions about which documents I intended to introduce as evidence and things like that. And obviously, that will be an incomplete list when I don't have any documents from you.
Mhm.
So do you want me, and I've given you all the documents I currently have from discovery from other people, not necessarily categorized by what I intend to introduce or not. But do you want me to, I'll still, I can respond to your questions, but a lot of it's going to be, I don't know yet. Or do you want me to respond after the 8th, like within, by the 12th of July, respond to your.
Here's how you can respond. You are not required to tell me what you don't know. You're only required to tell me what you do know. And if you know that you're going to use certain documents, or you're reserved the right to use certain documents, or there are other documents that are relevant that don't fit those two categories, you can identify them. Certainly, you cannot identify documents you haven't received yet from me, but I wouldn't be unfairly surprised if you use documents that I later produced to you, which is the point of that request.
Well,
So why don't we make this?
My
Okay.
proposal was to you, Mr. Bray, was
See, I would like the
I
documents.
want to have you have
carefully
answers as
deposition.
to what I intend to introduce. So
Right.
I don't want to give you answers of, I don't know what I'm going to introduce because I don't have all the documents yet. So I'm making a good faith response to give you as best response as I can give. And what I would say based on that is, if you respond to the discovery, me doing the Rule 34 thing by July 8th, we're doing my deposition on the 13th. I'm pretty quick. So by the 13th, that I give you back your responses, but a more complete set of responses, because I've had a chance over that weekend to look at whatever you gave me back and make a more accurate representation of what I intend to introduce as evidence.
I would like your response.
My suggestion-
Discovery before we do the deposition.
Okay.
I mean, I understand that.
But as it relates, this is Scott Norman, as it relates specifically to what he intends to introduce as evidence at trial, my suggestion would be, why don't we make it July 20, which is 7 days after he's deposed. It gives you, Don, the opportunity to ask him whatever questions you want, and then it gives you ample opportunity to see what he intends to introduce at the time of trial.
Well, here's the problem with that. I want those documents that he has and knows he's planning to introduce before I depose him, not afterwards. You know, now, hopefully if I get him our discovery before then anyways, it won't matter. But we're talking about a July 13th deposition. And we have a July 20 response to our written interrogatories. We're not going to have the ability to prepare for his deposition based upon those responses.
What are you still missing from Mr. Hicks in regard to discovery?
Well, he hasn't responded to. He's given some pieces of paper. I don't know whether they're responsive or not. As he indicated, he didn't say that they were responsive to any of my requests or not. You know, documents that he provided apparently are what he got from other parties. Don't know whether he considers all of them relevant. Don't know whether he considers some and not others. Don't know whether he plans to introduce them or doesn't plan to introduce them, which is what you identify in the document response. You know, categories A, B, C, D. You know, and then
let's be clear, Mr. Bray. The entirety of discovery I've provided to you, and it's under 200 pages, including I can't remember whether my original complaint was part of that. So I've been involved in stuff where lawyers are producing tens of thousands of pages in cases. It's not like we're talking about some intergalactic set of documentation. I consider all of that documentation to be relevant, and all of it subjected to be introduced at trial.
Well,
and it's not that much of it is the key point. It's not like I'm asking you to sort through a 10,000 pages. The whole thing is only about 180 pages.
Mr. Hicks, let me dip my foot in the pond. Mr. Bry, would it be too much for you to scan those documents and send them to Mr. Hicks and say, these are the documents you produced. Do you intend to produce any other documents other than what we produce? And then knowledge of what he has. Is that?
Yeah, I mean, I would probably do that at the deposition. That's one of the reasons why I want to get the universe of what he's got and then ask him about that stuff, as well as ask him.
So, Mr. Norman, just for clarity, I'm sorry for interrupting, but I already gave him the documents in scanned format and indexed. I mean, so he already has scanned format documents indexed of my entire discovery. So it's not, it's not, again, I don't have to, yeah, I've already done what you've said and more, because I OCR'd the documents and scanned them so that he can actually search on any term he wants to within them.
I'm just telling you, we as lawyers are a little different. We're wired differently, and he doesn't want to be hit with any surprises. So what I'm asking him to do, these are the documents that you're relying, other than what produces to you eventually in discovery. He doesn't want to have to walk into a trial and go, wait a second, Mr. Hicks. You gave this stuff before. So what I'm asking him to do is say, here are the documents. Other than what I produce, this is what you're going to rely on if we have to go to hearing.
Okay.
Right.
Mr. Chair.
Go ahead, Catherine.
Mr. Beatty. You're muted.
Go ahead.
I'm going to make a motion for a consent discovery order that I'm going to say right now, and the parties can agree or not agree, but this is going nowhere. So we got to get something down to vote on. So, Mr. Hicks, I understand that you are willing to withdraw your motion to compel. Is that correct?
Yes.
Okay. And are you willing also to withdraw at this time your motion to quash the subpoena, which is relating to the discovery that Mr. Bry is going to provide? Now, understand that there's going to be an order that says what he has to provide. So are you willing to also withdraw that motion to quash?
Yes.
Okay. So here's going to be my motion. Phil, can you write it down?
I'm right already.
Thank you. So the first is that the commission accept the complainant's withdrawal of his motion to compel. The commission accept the complainant's withdrawal of his motion to quash. Mr. Bry, are you willing to withdraw your motion for dismissal? For lack of personal knowledge, without prejudice?
Without prejudice to refile, and I probably want to refile after his deposition anyway. Sure.
Okay. So the commission will accept the motion to dismiss of the respondent. All of these are without prejudice.
I mean, to withdraw the motion to dismiss.
Right.
Withdraw. That's what I intended to say, Mr. Hicks. If I didn't, my apologies. So we were going to accept the respondent's motion to withdraw, his motion to dismiss. All motions are being withdrawn without prejudice, subject to refiling should the circumstances arise.
Mhm.
That the complainant will immediately proceed to request any discovery that he is asking for in accordance with civil rules. That the respondent, the commission accepts the respondent's agreement to respond to any of those discovery requests within 14 days of receiving them.
I think it was actually 13.
Well, yeah, although that was before we
Right.
moved.
I
Yeah,
think we're
14
okay
is
with
okay.
14. I think we're okay with 14 because we changed.
Okay.
it.
Because of the change of the deposition thing.
Right. That the
Okay.
complainant shall that the respondent will respond to any civil rule discovery the respondent receives from the complainant within 14 days of their receipt.
Thank you.
That the complainant will submit to a deposition by mutual agreement of the parties on July 13th, 2021 in Hamilton County.
Claremont.
In Claremont County. My apologies, Mr. Hicks.
No worries.
Claremont County.
Do you want to put the specific location and the time for start of that?
If the parties want to stipulate that, Mr. Hicks doesn't know for sure if he can get the room. So I was just going to say the date and time and general location. And you guys, if
Okay.
you have trouble working that out, that is something that you can contact the commission about and the executive director. That does not be part of the
Yeah,
motion.
I'm thinking start at 10:30 or 11. Is that too late for you?
For me,
Mr. Hicks,
I get caffeinated early, so we can go whenever you're, so 10:30 is fine.
so let's say 10:30 a.m. in Claremont County. Now, I'm going to interject this, that the parties submit to the commission all exhibits they intend to introduce at the hearing no later than August 12th, 2021, which is 2 weeks before our meeting, commissioner regular meeting date. So the commission before, I guess I'm going to say August 11th so that the commissioners can have them distributed to us at our meeting. And that I'm going to say, if the parties do not submit documents that are going to be exhibits at the hearing, we are not as a commission going to accept them. So that way you can supplement your discovery, you can update or whatever. Anything that's coming in as a hearing exhibit has to be pre-filed with this commission on or before the 11th of August. And that this matter be set for full hearing before the commission on August 26th of 2021.
Madam Commissioner, I have one objection to the requirement that respondent produce all of the exhibits. If you say all the exhibits that they know they're going to produce, that's one thing. But there may be some exhibits that we don't know are relevant until we hear the presentation of complainant's case. And we can't be barred from producing
rebuttal exhibits. Yeah. Yes. Acknowledged. And Mr. Hicks, what that means is, since you're the complainant, you have the obligation to prove the primary case. Since respondents don't know exactly what testimony is going to come in or whatever, they are, under the civil rules, entitled to bring as rebuttal, that is, in direct response to what you present, evidence that may not have been on their exhibit list. And that is not an unusual request. That is a standard trial requirement. So he doesn't have to have those as an exhibit list in, because he won't know till he hears the evidence whether he's going to put it in or not. So that is a fair request, but it is limited only to rebuttal evidence. If it is related to his defense in chief, he would have to have provided that to us.
By the way, I know you're in the middle of reading this. We could put UT Civic Center. I pulled up the calendar and the rooms are available, so I will not have a problem reserving a room. Union Township Civic Center in Claremont County, Ohio.
Can you give us an address?
Yeah, other than, here, 4350, I'm sorry, I didn't make this road name. Eichholz, Aichholtz Road,
Okay.
4350 Eichholtz Road, Aichholtz Road, Cincinnati 45245.
Okay. Now, that is my motion. Before we ask for, I guess I should say, Mr. Chair, with your grace, do the parties understand and have any objection to what I have said?
I'm a little bit concerned about the limitation or perceived limitation of unanticipated exhibits being barred from the respondent. And I realize that you're limited to rebuttal, but this, I think, goes a little beyond the rules as they've ordinarily been applied on these things.
I guess I'll leave it to my fellow commissioners. If somebody can in good faith argue why they should be allowed to introduce it, I'm not going to have an objection at the hearing, but that's my suggestion. Understood. Mr. Hicks, do you have anything else that you want to say about what I've proposed?
No. No.
Okay. That said, I would look, Mr. Chair, for a second so that the commission can discuss it among themselves. And bar
Second,
any
Commissioner Norman.
additional participation by the parties.
We've had a second by Commissioner Norman.
Correct.
Is there any further discussion?
I think Mr. Bry's concerns can always be addressed by a motion as we approach
Okay.
additional evidence that he wants to consider. I think therefore, Mr. Hicks, they can file a motion with the court and we can certainly as a commission address that. What we're trying, I think it was well said, we can avoid any type of surprise at hearing. So if there's an issue and you want something to come before us, then just file a motion and we'll address it at the date of the hearing.
Okay.
Okay, any other discussion? Commissioner Bromer, any more questions or discussion?
No, none.
Commissioner
Hicks, do you feel-
Kaufman?
No, I think this is a great coming together.
I just have a question for Mr. Hicks. Do you feel comfortable with how we're proceeding, sir?
Yes, I think it's great progress.
Okay, I just wanted to make sure. Thank you.
And Mr. Richter, I would appreciate it if the chair could memorialize that as quickly as possible and maybe with the approval of Mr. Beatty as chair, get it out and issued to the parties as soon as possible.
Be able to get it out by tomorrow.
You mean the executive
Right, Mr. Richter.
director memorialize it?
Correct.
Okay.
Yes. Yeah, just you review it, Otto, and maybe, yes, Mr. Beatty, as chair of the meeting, this portion of the meeting also would get a second set of eyes on it to make sure that we're good.
Okay,
By some point tomorrow, I will have it emailed to parties after I produced it and circulated it to Mr. Beatty for initial review.
Thank you.
Catherine, well done. Thank you.
We need a vote.
okay, we've had a motion that's been seconded. At this time, let's have a vote of the commissioners by raising their right hand and indicating by aye.
I think in this one, we should probably do a roll call just to be safe.
Fair enough. Senior Director Richter, roll call, please.
Not a problem. Mr. Brewer,
Yes.
Ms. Kaufman,
Yes.
Mr. Norman,
Yes.
Ms. Cunningham,
Yes.
Chair Beatty.
Yes.
That motion passes 5-0. And I'll just add too, as a matter of course, I think, considering this is just motion hearing, et cetera, and setting this for stage, even though Ms. Tavares left, she'll be able to sit for the full hearing when we actually have it on August 26th. Because she's not prejudiced in not hearing any of this. She'll hear the evidence when the hearing is presented, just to make that clear in that point.
I have one procedural.
Mr. Richter, looked like Mr. Hicks had another question.
Okay, go ahead.
Okay, so for the 26th, I will want to subpoena a few, not a lot, of witnesses. And I want to make sure that I do it properly according to the commission rules. So I just want to have a general, well, we're all here, of the correct process for subpoenas for witnesses. And in that case, do I get it to the director and does he issue the subpoenas, or is there some other process that's supposed to take place?
Nope. You would submit those names to me that you would like to have attend the hearing.
You're breaking up, Phil.
Oh, am I? Sorry. You would submit those names to me of the persons that you would like to attend the hearing on that date, and I will circulate the subpoenas and have them served by, unless you have a specific request to have a specific process server, they will be served by the subpoenas in the appropriate county where that person is resident.
And by what time should I have that to you for a August 26th hearing?
I'm not trying to delay here, but and I'm not saying you have to get it to me by tomorrow, certainly, but the earlier the better, just, to make sure that we'll service the process, but probably no later than the beginning of August.
I'll get it way before that. I just wanted to get a feeling of time frame.
Right.
To
Understood.
give people adequate time to prepare.
Mr. Hicks, I will say, in what's probably going to come to an end for the COVID era for commission, this is probably going to be an in-person. So it would probably be sooner rather than later than getting those subpoenas, because we have to travel to Columbus.
Yes.
Well, and you're also relying we're relying on the local law enforcement, the sheriff or whoever, to serve those, and that's not always their top priority. So sometimes it takes longer than one might expect just to get it served.
Okay.
Right. And that's why I said, probably no later than very early August.
Yeah.
I mean, we've had situations before where subpoena requests have come in late and it's actually worked, but it's hard because we're relying on service process by somebody else.
Okay, I'm going to ask that we move on with the agenda because like Commissioner Tavares, I've got a commitment at 3. So we've got to move on.
All right, I'm back in play. So
Welcome back.
yeah, I'm going to do the group considerations at this point in time.
Thanks, Mr. Hick.
Thank you, Mr.
Thank you,
Hicks.
gentlemen.
Thank you, Mr. Bry.
Thank you,
you all.
gentlemen. We appreciate you both.
Case number 2021R-100, Phyllis E. Cleveland et al. It's been withdrawn by the Board of Elections. No action necessary. Is that right, Mr. Richter?
That's correct. You have, just by announcing it, you've acknowledged it. We're done with that. Move on.
All right, under the good cause category, case number 2021R-054, 2021R-055, 2021R-061, 2021R-074. Executive Director has recommended that we find a violation, but for good cause, not impose a fine or refer for prosecution. I entertain a motion.
So moved.
So moved.
We have a second.
Second, Norman.
Further discussion? All in favor of the motion signify by saying aye or raising your right hand.
Aye.
Aye.
Opposed, same sign. Motion carries. Under the $50 fine category, case number 2021R-057, 2021R-078, 2021R-079, 2021R-080, 2021R-099, 2021R-102, and 2021R-108. Executive Director recommends that we find a violation and impose a fine of $50. Is there a motion?
Cunningham, move that we follow the Executive Director's recommendation.
Do we have a second?
Second, Beatty.
Discussion by the commission. All in favor of the motion signify by saying aye. Raise your right hand. Aye.
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 Same sign. Motion carries. Now into the $100 fine category. Case number 2021R-052, 2021R-053, and 2021R-097. The Executive Director has recommended that we find a violation and impose a fine of $100. Do I have a motion?
So moved, Brommer.
We have a
Second, Norman.
Further discussion. All in favor of the motion signify by saying aye and raise your right hand.
Aye.
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 Opposed, same sign. Motion carries 6-0. $150 fine category. Case number 2021R-065, 2021R-081. Executive Director recommends we find a violation and impose a fine of $150. Is there a motion?
So moved, Norman.
Second,
Second Cunningham.
Kaufman, second.
questions? All in favor of the motion, signify by saying aye, raising your right hand.
Aye.
Motion
Aye.
carries by a vote of 6-0. Next category, consolidate case numbers 2021R-040 and 2021R-082.
We dealt
Second.
with that already, so
you're
that
right.
one has been
I've got
resolved. We can move on to $200 fine.
All right, thank you. $200 fine. The executive director has recommended that we find a violation and impose a fine of $200 in connection with case number 2021R-103. Is there a motion?
So moved,
Cunningham.
Beatty.
Second
yes.
Cunningham.
All in favor of the motion signify by saying aye and raising your right hand.
Aye.
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 Opposed, same sign, motion carries. Next category, reconsider case numbers 2017R-417 and 2017R-056. Vacate the previous finding, consolidate those cases with case number 2021R-058. Find a violation and impose a fine of $750. Do we have a motion?
So moved, Norman.
Second,
Second Kaufman.
all in favor of the motion, signify by saying aye and raising your right hand.
Aye.
Opposed, same sign, motion carries. Next category is the $1,000 fine category. Executive Director has recommended that in case 2021R-098, that we find a violation and impose a fine of $1,000. Is there a motion?
So moved Kaufman.
Do we have a second?
Second, Norman.
All in favor of the motion, signify by saying aye and raising your right hand.
Aye.
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 Opposed, same sign. Motion carries. Next category of cases, $25 fine, fine violation, impose a $25 fine, $25 a day with reconsideration option in case numbers 2021R-059, 2021R-068, 2021R-071, and 2021R-104. Is there a motion?
Did we deal with 104? I'm sorry.
No, we did not deal with 104. We dealt with 076.
All right, so is there a motion?
Do we need to include an additional case in that category?
2021 R-104.
I think I
Okay.
We
read,
added.
I already read that one.
Okay,
Right.
sorry.
Here are the cases again, so there's no confusion. 2021R-059, 2021R-068, 2021R-071, and 2021R-104. $25 a day fine with reconsideration option. Do we have a motion?
Cunningham, move that we follow the executive
Against.
director's recommendation.
And a second?
Second, Norman.
Thank you. All in favor of the motion signify by saying aye, raising your right hand.
Aye.
Opposed, same sign. Motion carries. In connection with the next category of cases, 2021R-085, the executive director recommends we consolidate with case number 2021R-380 and find a violation and impose a fine of $25 a day with reconsideration option. Do we have a motion?
So moved, Norman.
Do we have a second? Second by Kreitz. All in favor of the motion, signify by saying, raising your right hand and signify by saying aye.
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 Opposed, same sign. Motion carries. Next case, 2021R-089. Executive Director recommends to consolidate with case number 2020R-382. Find a violation and impose a fine of $25 a day with reconsideration option. Is there a motion?
So moved, Brommer.
A second?
Second Cunningham.
All in favor of the motion, signify by saying aye and raising your right hand.
Aye.
Aye.
Opposed, same sign. Motion carries. Next category of case, 2021R-070 and 2021R-094. Executive Director recommends finding a violation, $25 a day fine with reconsideration option with payment of $250. Do we have a motion?
So moved, Norman.
All right, do we have a second?
Second, Beatty.
All in favor of the motion, signify by saying aye and raising your right hand. Aye.
Aye.
Opposed? Very good. Motion carries. Next category, case 2021R-062. Consolidate with case numbers 2020R-415, 2020 R-104 and 2019 R-446. Find a violation and impose a fine of $25 a day with reconsideration option with payment of $250. Is there a motion?
So moved, Brommer.
We have a second.
Second, Norman.
All in favor of the motion signify by saying aye, raising your right hand. Aye.
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 Opposed, same sign. Motion carries. Case number 2021 R-093. Consolidate with case number 2020 R-473. Find a violation and impose a fine of $25 a day with reconsideration option with payment of $250. Is there a motion?
So moved,
So-
Kaufman.
Second, Norman.
All in favor of the motion signify by saying aye and raising your right hand.
Aye.
Opposed, same sign. Motion carries. Next category, 2021 R-064. The Executive Director recommends $3,600 fine plus $25 a day with reconsideration option. Is there a motion?
Cunningham, move we follow the executive director's recommendation.
Do we have a second?
Second, Brommer.
Second.
All in favor of the motion signify by saying aye, raising your right hand.
Aye.
Opposed, same sign. Motion carries. Next category of case, 2021 R-063, 2021 R-084, 2021 R-088, 2021 R-091, and 2021 R-101. The Executive Director recommends imposing a fine of $14,400 plus $100 a day with reconsideration option. Is there a motion?
So moved, Norman.
Is there a second?
Second, Kaufman.
Right, a second by Kaufman. All in favor signify by saying aye, raising your right hand.
Aye.
Opposed, same sign, motion carries. The next category of case, 2021 R-087, continue upon request of staff attorney. Any action necessary on that, Mr. Richter?
No, if you declare all those continued, those matters will be continued. There were a couple of cases we've already
Okay, I'll get to that.
decided, but, you know.
All right, 2021
I'll deal with those separate.
2021 R-056, continued upon request of the respondent, will be so continued. And the following cases are recommended, continued for service. 2021 R-051, 2021 R-060, 2021 R-066, 2021 R-067, 2021 R-069, 2021 R-072, 2021 R-073, 2021 R-077, 2021 R-083, 2021 R-090, 2021 R-092, 2021 R-095, 2021 R-096, 2021 R-106, and finally 2021 R-109 been continued for service.
Thank you very much.
Other category is other business. Anything further to come before the commission? Next meeting is July 15th, 2021.
And I'll quickly interject just to say I would anticipate that that will be in person. I received some materials from Mr. O'Brien that I've been reviewing over the last couple of days and trying to interpret it. He works on the Liquor Control Commission, and they are anticipating continuing to meet remotely as a board because supposedly somewhere in the budget bill, there has been something that said that there is an allowance for that. I have not, now, I mean, the budget bill is 3,000 pages long. I have tried
You
to
haven't read
skim
it yet,
through.
Bill?
I'm sorry,
You haven't read it yet?
I have not read it yet. I apologize. In trying to skim through and see what they've supposedly interpreted as certain provisions that would allow remote meetings, I haven't been able to find that in there that may be an allowance. And so unless you hear otherwise from me, on July 15th and thereafter, we will be meeting in person here in Columbus, Ohio.
Very good.
If something changes and I become aware of anything else, you will certainly be the first persons that I contact about.
Okay. One final thing very, very quickly is that we missed doing Phil's evaluation last summer because of the pandemic. So we need to get back in the loop on that. So that needs to be done in August, certainly no later than September, depending upon what the docket looks like in August. So something just to begin to bear in mind. I'll get some information out to you a little bit later. Anything else?
Oh, I've got some notes. I've got some notes.
When's the
Especially
budget bill
after today,
deadline?
right? I'm sorry, what?
When's the budget bill deadline? Is it end of July?
June 30th. Isn't that June 30th?
June 30th, unless they
June
do something, in, as a carryover, but, it's coming up. It's coming up.
Okay.
I've got a question going back to our in-person. Obviously, if we go back July 15th, we're there. Are we going to continue to allow people to appear by video like we have? We're actually getting people to attend?
No,
I don't think we
because,
can.
the allowance in the statute was not only for members, but also for persons wanting to participate, to appear remotely. You had to provide notice to do so, which, we did. We changed up so that we had the ability to do that. If it changes and we're able to do it, we would get a notice out there somehow to everybody that says, here's how you could link back in. But at this point, no, it will be, not only you guys, but anybody who wants to appear before us must do so.
I think something that needs to change.
That leads into, I do have a question if that's okay.
Sure, go ahead, Chris.
Once we go back to in-person meetings and anyone wishing to address the commission or participate in a meeting will have to be in person as well. Would the commission be interested, being as we do have a YouTube channel, which is how we have to upload our videos in order to get them onto our website, etc. And it's really been a novel idea to have the meetings recorded. I know we do have a court recording service that does a fantastic job, but it's kind of nice being able to go back and watch those videos should you want them. Would the commission be opposed to having a camera set up that's recording, not for anybody participating, but for viewing purposes at those in-person meetings, to where I can still upload those to YouTube? They can still go on our website, that should someone want to watch our meeting, they have that ability just to click right on the video and they can view it.
I would, I don't know what that is.
What was that?
It sounded like a pool.
I think that's
that would
Mr.
be,
Hughes' family there.
That would be the boys. I was out here just as they did a cannonball.
That's pretty cool. Go ahead, Otto.
I think that is actually an excellent idea for a number of reasons. And it even goes to me, although it would not be live, it does help with access, because if the attorney appears, their client can't be there, or it's a group that's being represented, they can't all be there.
Yeah.
They can then see that video as to what happened, what the reason for the decision was, et cetera, et cetera. I think it'll really provide some great transparency.
I'm only
Any
afraid
other reasons as well.
the budget site, who's going to pay for it?
Well, everything that we have thus far has been free. And so just as, with Phil, if Phil's got a laptop, I've got a laptop, et cetera, that all you have to do is press record when you go up to the free YouTube channel and just hits live recording. So anybody that would follow the commission would get a notification, just like you would with a sunshine notice, saying, hey, the commission's now going live, and they can log on and watch it as it's happening. And once that's done, it's saved to our library to be uploaded to our website.
Will that be downloaded for tonight, Chris? Today's meeting?
Now, right now, being as I am on vacation this week, it may.
You don't have
Monday.
to answer. I was just wanting to be a smart ass because I think I'll lay
Cannonball
all over tonight.
But I do think I try to have the videos uploaded to the website same day as the meeting, as well as the signed minutes, all that uploaded, so it's pretty quickly.
So you wanted popcorn this time, right, Dennis?
Yeah.
We've already taken a day out of his vacation, so I don't know that we need to do any more for Chris than that.
Yeah, you're a good man,
we
Chris.
appreciate your giving up your vacation day, Chris.
Not a problem. Not a problem. I brought my computer for a multitude of reasons. I mean, just being the end of the fiscal year, my biggest worry was that something was going to happen and Phil go, we forgot to do this, and then I'm stuck. And so it's like, I bring in the computer just in case.
That would not happen with Phil.
No.
And honestly, I think the background is an appropriate end to our meeting today. So we appreciate that.
So do we have a motion to adjourn?
So moved.
All right, thank you,
Second.
Tasha. Thank you, Catherine. All in favor signify by saying aye and by departing the
Aye.
pattern. Aye.
All
All
right.
right.
Thank
Take care,
you.
all.
Thanks,
Thank you.
everybody.
Bye-bye.
Thanks for
Thanks,
your
everyone.
willingness
Have a
and
good
patience.
vacation, Chris.
Oh, most welcome.
Thank
Enjoy
you,
the
Chris.
vacation, Chris.
Oh, thank you. It's been beautiful down here.
Where are you, actually?
Marco Island.
Oh, I've got a place in, you saw me all winter. I was up in Miramar Lakes, which is about 40 minutes north of you.
Oh, not far at all.
But I love
It's-
Marco Island Beach is my favorite. It's beautiful down there.
Oh, it's gorgeous. Absolutely gorgeous.
Did you go down to Tiger Tail Beach?
We have not yet. That's on the list. We were wanting to go today, but I think it's going to be raining this afternoon, so we may wait till tomorrow.
It is spectacular. Do go enjoy it.
It's worth the drive up to it.
Absolutely. Yep.
Wonderful. Well, thank
All right,
you.
enjoy.
Gentlemen, see you
Bye.
later. Thank you very much. Mr. Bromer, have a good one. Scott?
Yes. Enjoy, Chris.
All right, thank you.
Thank you, Christopher. Greatly appreciate your diligence and patience here. You've gone above and beyond.
No worries at all. As I said,
Appreciate it.
I had the computer, and it's our last virtual meeting as of right now. And so, considering what was on the docket and everything, it just would certainly help to have even an additional.
Well, yeah, I'm in my conference with chatting with Chris, and his kids are still diving in the pool, but yes. No, they left shortly after. They were here for Hubei, and once that was done, they bolted. He did seem very this is a piece of work, isn't he? Yeah, Chris, you can go. Just go back and enjoy your family.
Well, thank you.
Take care. Yeah, I mean,